The next case to come before the court is Member Williams et al. V. Kisling, Nestico, and Redick LLC et al. Each party will have up to 15 minutes to present their arguments. I know we have two appellants, and you will have to share your time to discuss that. You may reserve up to 5 minutes for rebuttal, and if you guys do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. Please keep your voices up, remain behind the podium, introduce yourselves. You should not use the names of children or minors or victims should that be relevant to your argument. The judges have read your briefs and we're ready to proceed when you are. And I would just ask the appellants right now, how would you like to divide your time, and would you like to reserve any time for rebuttal?
Yes, Your Honor. Eric Kennedy, in behalf of Appellant KNR, we have agreed to divide the time equally. In behalf of KNR, we would be reserving 2.5 minutes for rebuttal.
Thank you, Your Honor. Brad Barman for Appellant Sam Gabriel. I'll also reserve 2.5 minutes for rebuttal.
Okay, then we are ready to proceed when you are.
Thank you, Your Honor. May it please the court, as I said, my name is Eric Kennedy. I represent Appellant Kisling, Nestico, and Redick. We are appealing here today the trial court's certification of a class action involving alleged overcharges by Appellant Dr. Gabriel. KNR is a law firm. I think that the record is uncontested that they had no role in determining the charges of Dr. Gabriel. I think the record is uncontested that they played no role in determining the care and treatment to be prescribed to class members, the subject matter of this lawsuit. And the record, I believe, is uncontested that in the 13-year class period, KNR rarely referred any of their clients to Dr. Gabriel for care and treatment. This appeal before this court is the second appeal of the trial court's certification of this class. In Williams 1, the first appeal to this court found, and I quote, that the trial court failed to undertake a rigorous analysis with respect to the requirements of Rule 23. The court's focus in Williams 1 was the requirement of predominance with respect to the failure of the trial court to do a rigorous analysis. The trial court's response in Williams 2 was to exclude certain class members from the class and to formulate what appears to be 9 subclasses. It's black letter law that each subclass must independently establish and prove the requirements of Rule 23. The law is uncontested that each individual subclass must undergo the same rigorous analysis that the class in its entirety must undergo. The trial court, again failed to perform a rigorous analysis with respect to each individual subclasses. In fact, if we look to the opinion of the trial court now in Williams 2, there is not even a discussion of numerosity, typicality, commonality, predominance, and with respect to superiority, there is nothing more than a truncated analysis that doesn't even address the most important element of superiority, and that is manageability. Most notable, not a single one of these 9 subclasses has a class representative. The trial court excluded from the class all class members or potential class members who had received a reduction on the original billing and charge of Dr. Gabriel. In effect, every single named class representative in this case has been excluded from the class, which means that not a single subclass has a class representative, and the class as a whole has not a class representative. The law is black letter. You cannot proceed with a class action, subclass or class as a whole, without a class representative. It's impossible without a class representative to establish the element of typicality. Without a class representative, it is impossible to have a representative trial where the class member's case is representative of the typical claims held by all the folks in the class. Cannot proceed. We cited 4 cases for that proposition. long and hard, but we could only find 4 cases. And that's because it is literally unprecedented that someone would even seek to pursue a class action without a class representative. In Williams 1, this court specifically stated, quote, "The trial court failed to undertake a rigorous analysis of how plaintiffs could prove liability with common evidence when individual class members have different health insurance coverage." In Williams 2, the trial court again, even though it formulated these subclasses, the trial court once again failed to provide any sort of rigorous analysis, in fact, any analysis, as to how you can possibly proceed with this case to trial, adjudicate the claims of all class members with common evidence in a single proceeding where every class member has different health insurance coverage. Some have Medicare, some have Medicaid, some have Blue Cross, some have Blue Shield, some have travel, some have Unum, some have co-pays of $100, $50, $1,000, some have deductibles. Cannot proceed, and again, the trial court literally failed to provide any sort of analysis with respect to that issue in this case. And finally, in Williams 1, this court found the trial court, quote, "did not conduct a rigorous analysis when it summarily concluded that disgorgement was an appropriate remedy."
I do want to let you know you used your 5 minutes.
Already, got 1 minute left, and I'll take off my
Sure.
rebuttal. With respect to disgorgement, Your Honors, the trial court once again failed to conduct any sort of rigorous analysis. The trial court did nothing more than cite a single criminal case in its opinion, a criminal case that has absolutely no application to the issues that are raised with respect to a disgorgement remedy in the context of this class action. Thank you.
Thank you. You may proceed.
Thank you, Your Honor. Pleased to court. Again, Brad Barman for Appellant Sam Gabriel. Certainly, I'm in league with Mr. Kennedy and his arguments, and I incorporate them herein. I'm not going to repeat them for the sake of time. What I want to focus on is both for the issues of liability and damages as it relates to my client. Individual issues predominate such that there can be no common questions resolved by common evidence. Injury, in fact, is a threshold issue, and damages is an essential element to every claim pending against my client, so we can focus on the fraud claim because everything focuses in after that. Plaintiff has focused entirely from 2018 forward on this issue of overcharges, but he doesn't talk about what people actually pay, and it segues into what Mr. Kennedy said about the fact that the charges themselves are irrelevant. What people actually paid is what's relevant here. And everybody had a reduction, as Mr. Kennedy said. All named plaintiffs had a reduction. Judge Brogan saw fit to remove them from the class. There are no class representatives. Frankly, there are no proposed class members that have been identified to date that didn't receive some reduction in the charges. And again, the charges themselves can't cause damages. So you go back to the issue of predominance and common questions. You would have to look at each individual and see what their end result was, what they actually paid to resolve the charges. Then you have to compare what they paid to issues like, did they have insurance? What would the reimbursement have been? Did they have Medicare? What would be that reimbursement? And you don't just stop there. You have to look at it for the actual time period they were charged during the 13-year class period. One of the cases that the plaintiff himself cites talks about the fact that the relevant thing to look at when you're talking about medical charges is what's reasonably paid at that time and place. How do you do that here without looking at each individual and doing an individual mini-trial to see what they were charged, what the reduction was, although that takes them out of the class according to Judge Brogan, and there remains, at this point in time, no class to speak of. There's no numerosity, there are no named party representatives, they're all gone. So at this point, one of the things I also want to talk about in the few minutes I have left is in Williams 1, this court realized the applicability of the Felix case. And in fact, in the remand, indicated to Judge Brogan he had to account for that case. In Williams 2, he did no such thing. He didn't even mention it. He didn't do any analysis at all, and again, Felix stands for injury in fact. He did no analysis of that whatsoever. He did no additional analysis. His solution was, we'll simply break things down into additional subclasses. And I know Mr. Kennedy said there's 9. Frankly, when you start looking at it versus the number of parties and the number of claims against each party, understanding that the claims against both KNR and Dr. Gubriel are different. The breach of fiduciary duty claim against Dr. Gubriel is gone. I submit you would need additional subclasses beyond the 9 for each claim against each individual defendant. So you're potentially looking at an unidentifiable number of classes when you break it down. Separate and apart from that, as Mr. Kennedy said, it would have been required for Judge Brogan under Rule 23 to do the rigorous analysis for each proposed subclasses. He didn't even attempt to do so. He simply just said, we'll get rid of people who received a reduction, we'll do additional subclasses, and that solves the problem. Well, I submit to you, it does not. And for that reason, Class A cannot be certified, and it should be remanded with instructions that it be dismissed as a class. Thank you.
Thank you very much. You will both have 2.5 minutes for your rebuttal.
Good morning. My name is Peter Patakos, and I represent the appellee class members. May it please the court. First, in addressing their arguments on appeal, I believe it's important to emphasize what is not at issue in this appeal. This is, as they referenced, the second time we're here before this court. This is the second time the trial court has certified this class. And it's important to note that the first time the trial court certified this class, it wrote a 56-page opinion setting forth its analysis in great detail. Now, the first time the defendants appealed to this court remanded back to the trial court for analysis of 3 limited issues. And what the defendants seem to want the court to do, unsurprisingly, is view these issues in a vacuum. But they cannot properly be divorced from the context of both the trial court's extensive opinion certifying the class and this court's affirmance of the same as to the issues that are not at issue in this appeal. And I think it's very important to note that predominantly what is not at issue is that all of the class members, and we are talking about thousands of clients who are people who were put into the very same pipeline, and that is a high advertising personal injury firm that deliberately targeted socioeconomically disadvantaged clients, people who would hire a lawyer based on TV advertisements, and people that don't have lawyers in their network, etc. That is set forth in both the trial court's first opinion and this court's first opinion. And this court and the trial court emphasize the affidavit that we submitted from the Stanford law professor Nora Freeman Engstrom, who is the leading expert on the emergence of the type of high-volume, high-advertising settlement mill law firms that the defendants here are operating or were operating, that has emerged since the floodgates for attorney advertising have opened since the 1977 decision of Bates v. State Bar of Arizona. And what is not at issue here in this appeal is that there is evidence showing that these defendants took advantage of their high advertising, high volume business model that relied on quid pro quo referral networks with chiropractors that again targeted socioeconomically disadvantaged clientele. And this would allow them to exploit the phenomenon of medical buildup. Again, referred to in Judge Brogan's first opinion and this court's first opinion. And this is what allowed the defendants to enrich themselves at the expense of their clients. Now, Professor Engstrom explained that the overcharges were an integral part of this scheme because it allowed the defendants to inflate.
Counsel,
Yes.
Counsel, if you could just tell me, if you could respond to the notion that whether or not the trial court performed a rigorous analysis of whether Class A as a whole meets the requirements of Civil Rule 23B and whether the subclasses were also rigorously
Thank you, Your Honor, I will. And in doing that, I want to address and emphasize that Mr. Kennedy said that the trial court appeared to create 9 subclasses, but the court did not do that. The court kept the same class, which is everyone that was charged Gubriel's standard rates, and I should say billed at Gubriel's standard rates. I think that's an important distinction. Everyone who was billed at Gubriel's standard rates for trigger point injections, TENS units, and back braces. Everyone who was billed at those rates, the trial court has found suffered injury in fact. It's not an issue in this appeal that these rates that these people were charged pursuant to this scheme were excessive, were far in excess of what was commercially reasonable. And I do believe that the trial court referred to subclasses to show that he could do that if it became necessary. And here, I want to point the court's attention to a case from this court, 9th District, and this is in the case of Remedio v. Sumacare. And we cited the 2007 case, but there's a later case, I believe it's the same case, but it's a later opinion by this court, and that's 2010 Ohio 5555.
And is this case in your brief?
It is not.
Okay.
It is not, but I do think it's important, Your Honor, to address this idea that Judge Brogan had to name specific subclass representatives, because I don't think that's what he did. I think he left the class as is and said, I will create subgroups, and I think it's important to note the difference between subgroups and subclasses as well. What he really said when he went back is to say, look, this is still common evidence, that common evidence still predominates. These subgroups, first of all, he referred to the fact that many of these class members had Medicaid coverage. And there was a testimony, and there is testimony in the record from a former K&R attorney who says that 80%, upwards of 80% of this clientele had Medicaid. So that is a subgroup. That is common evidence. You don't need a new class representative to determine the evidence in that way. It's still the same class. The class members were all charged Gubriel's standard rates. And the court addressed that by discussing the fact that common evidence will show commercially reasonable rates from which the overcharges can be calculated for the different subgroups. Subclasses are not necessary. And I don't believe Judge Brogan created subclasses, but what this Remedio case says is that it wouldn't be necessary to do that in this order, and that's not really an issue that this court needs to worry about. The Remedio case says, to the extent that variations require distinct demonstrations of proof, subclasses may, if necessary, be redefined by the trial court. Determining the course of proceedings or prescribing measures to prevent undue repetition or complication in the presentation of evidence or argument is the point here. Courts' subclasses may be defined or redefined by the trial court as the class action proceeds. If the trial court deems it necessary, the court can redefine the subclasses according to how the evidence comes out. But right now, we don't have the information necessary to say exactly how many people are in these groups and what the proceedings would look like. But what Judge Brogan, who's an extremely distinguished and experienced appellate judge, has determined twice now is that this is manageable, that this is common proof, and we can determine for these different groups for Medicaid, which Medicaid is easy, those are standard rates. We have those rates in our briefing. That's a simple math problem. It's also a simple math problem for people who are uninsured and people who have private insurance once we introduce evidence of what a commercially reasonable rate is. And we've cited many cases in our brief that show that this is what courts do. Because otherwise you're just saying that fraud is okay as long as you defraud enough people, or that you collected different amounts after you overbilled them. So case after case in these difficult situations, I acknowledge it's a difficult situation, but I have to object to Mr. Kennedy saying that this is a unique case because we're trying to get justice here. It's a unique case because you have a law firm that has been taking advantage of a lot of people through advertising in a very standardized process that was allowed to continue for a very long time.
In part, what appellants are arguing, if I understand their argument, is that because the trial court, Judge Brogan, eliminated anybody who did receive a specific reduction of his bills from the doctor in this case, that all the named plaintiffs in this case, not all the people in the world out there, but the named plaintiffs, have all been eliminated from the class. Is that a fair statement?
Thank you for asking me that, because that's a very important point that needs to be addressed. I think it needs to be addressed by me and the court in its opinion. The court should look at page 4 of Judge Brogan's opinion that is being appealed here. It's at the bottom of page 4 and the top of page 5. And they are misrepresenting what the court actually did. Because what you see here is the price gouging class, and I'm reading this, Class A would include patients and clients who had no specific reduction of their medical bills for trigger point injections, TENS units, or back braces in their settlement statements. That's how he limited the class, and that was the right way to do it, because everyone that was charged these rates necessarily suffered injury in fact. They're now negotiating from a place where they have their lawyer and their doctor that they trusted who convinced them, oh, don't worry, waive your insurance, we'll take care of it, you don't have to worry about payment. They send him to this doctor who flies all around the state in an airplane that's named after the trigger point injections. And by the way, he's not a doctor anymore.
Do you have specific named members here that fit into that first class?
Yes, sir. Every single one of them. There's not a single class member who actually, I don't believe there is any class member. No named member. No named class member had specific reductions to say, okay, you only have to pay this much for your injections, this much for your TENS units, and this much for your back braces. They use the injections. I think one of the, Thera Reed spent an exorbitant, she received I think 5 or 6 rounds of these injections and was charged these exorbitant prices. And you know, I think Thera Reed, her testimony shows how damaging this kind of scheme was, because she was someone who was very poor, had very tough circumstances, and she needed a real lawyer and she needed a real doctor. Instead, she gets sent to their chiropractor, she gets sent to Gabriel's injection mill, and she doesn't get the surgery that she needs. And you know, we can't recover for that. The least we can do is get these overcharges back. And you know, I think that it's a very, I think it's a very bad argument to say that just because these people had different types of insurance or had, you know, that ultimately we collected a little bit less. I mean, you're saying that if you don't collect every penny after you defraud someone, that you're in a position of advantage over, that defeats class certification and effectively says that these people can't get relief. And the court has, Judge Brogan has emphasized that twice now, that if these people can't recover in this case in a class action, then there's functionally no way they can recover anything.
How did he adequately address the issue of disgorgement of K&R's fees in this case?
Well, I think what he said was, look, look at this scheme. If we can prove K&R's involvement in this scheme, and you know, he addressed this in his first opinion where he says that Mr. Nestico would have had to know this. I mean, when Mr. Kennedy says to this court that, you know, they didn't send their clients to treat with Dr. Gabriel because it was the chiropractor, I mean, there's all kinds of evidence that this was a scheme that they were all in on together. And that evidence, again, is not at issue in this appeal. So he's misrepresenting the record when he says that. But effectively, by Judge Brogan saying, look, if anyone actually received a specific reduction for trigger point injections, TENS units, etc., then we'll remove them from the class because that removes the problem. And then he says, look, and these insurance, the large groups of these class members are similarly situated with respect to insurance. I'm comfortable as the trial judge who has to run this, who has a lot of discretion in doing this, in sorting out that evidence through these subgroups. And I'll submit it's especially easy given all of the class members that were on Medicaid. So when he says, look, those aren't issues, and this is how we're going to resolve those issues, therefore, using a straightforward mathematical calculation, as you know, is he cited this court's opinion in Mozingo, Judge Hensel's opinion in Mozingo, this is a straightforward mathematical calculation. We'll use subgroups to determine the variables, and that is how we're going to proceed here. And of course, he really says, of course, disgorgement is an appropriate remedy if we can show that K&R was in on this scheme. And I would submit, after all the evidence, I don't really think it's at issue that the evidence has already been, the court has already said there's evidence showing that K&R is involved in this, and this court didn't remand on that issue. So, you know, I just think that this opinion has to be viewed on top of in the context of an already extensive 56-page opinion. And its endorsement of all the evidence and the arguments that we put in. And we did a lot of work on this case, and we presented a lot of evidence, and the court accounted for that evidence, and that evidence reveals something very egregious. So I know I don't get any rebuttal time, so I have a few more points that I can make here. I also think they don't address, and I think it's telling that Mr. Barman says that everything flows from the fraud claim. But there's also the breach of contract claim for both sets of defendants. And we cited a lot of case law at page 21 and 22 of our brief that cites various cases showing that where contracts are left with open price terms, the price that's eventually filled in has to be commercially reasonable. Again, we will introduce across-the-board evidence, common evidence, in fact we already have, showing that these rates on this open price term, even that's putting it kindly to call it an open price term, that's assuming that these clients had any kind of say over what these lawyers and doctors were doing to them. But they don't address those cases. There's the Master Chemical Corp case from the Ohio Supreme Court that says that where the open price term is left, that must be fixed in a commercially reasonable manner. There's the Malico Construction, Ogilvy Norton, Hillman, and Lucarelli. I think that's important, but again, I think in this court's decision it should emphasize that it's really the amounts billed. The word billed is what matters here, because when these people get billed, these amounts for these specific types of medical care that are dubious in and of themselves, they have suffered the injury, because now they were already disadvantaged, now they're disadvantaged even more in this little mini scenario where then they sign off on their settlement statements.
Councilman, we have to ask you to wrap up.
I will wrap up, and I will ask this court to affirm and let us and Judge Brogan do our jobs and remedy this, something that this court should be very concerned with, as should every court in this state. Thank you.
Thank you, Council.
Your Honor, again, Eric Kennedy, in behalf of Appellant Anna. And I just want to take a moment, because it's a continuous issue that we've had in this litigation, and that is Appellee's refusal to address the actual issues. It occurs at the trial court, it occurred here. Appellee started the argument, let's talk about what's not an issue. And had the court not asked a question, we would still be talking about what is not an issue. Appellee wants to focus on it's an advertising law firm. They're targeting poor people. This is chiropractors who have been dismissed from the case. They want to talk about a case that's not in the brief. They want to talk about the fact that Dr. Guberell is no longer a doctor. Those are not the issues before this court. What is not before this court is the 56-page original opinion of the trial court. What is here in Williams 2 is this court's 6-page opinion. And we seem to have two opinions. We have the opinion that the trial court wrote, and we have the opinion that appellees wish that the trial court had wrote. The trial court, I don't know how you get around the clear language of the trial court that they excluded everybody from the class that had a specific reduction. Appellees seem to be playing in the word specific, that nobody actually got a specific reduction. Every single closing sheet of every single named class representative has a dollar amount to the penny of what has been reduced and what they owe Dr. Guberell. Specific reduction in every case. Appellee's argument that the trial court endorsed their arguments. The trial court didn't endorse the arguments of appellee. The trial court simply repeated the arguments. The heading of the paragraph that they cite is appellee's plaintiff argued, and then lists their arguments. It's not an endorsement, it's a repeat. And the very next page says defendants argue, and then lists defendants' arguments. It's not an endorsement by the trial court, it's a repeating of the arguments made by each party. Additionally, with respect to disgorgement, the trial court did not address this court's concern in holding that there was no rigorous analysis with respect to how disgorgement is appropriate, given the fact that its computation would require individual computation with respect to each individual plaintiff. Appellee gets up and says, well, the trial court found that disgorgement is an appropriate remedy when somebody commits fraud. Well, you know what? They are right. It is an appropriate remedy under those circumstances. But in the circumstances of a class action, not a criminal case that they cite. In the circumstances of a class action, that remedy has to be able to be calculated in a simple, direct, straightforward fashion, and it simply cannot, as this court indicated in its opinion in Williams 1. And it was completely not addressed again in Williams 2. In conclusion, Your Honors, we would ask that this court reverse the certification by the trial court of this Class A. But we would further ask that you remand this case back to the trial court with instructions that no configuration of subclasses, and let me say, the court used the term subclass in one sentence, and in a sentence later used the term, she used the term subgroup, but in a sentence later used the term subclass. I have never heard of anybody get up and draw a distinction between a subgroup and a subclass. This court, trial court, used both terms. But we ask that this court send this back remand with instructions that no configuration, no arrangement of subclasses by the trial court can fit this case into the requirements of Rule 23. And further instruct the court that without class representatives, for the class as a whole or subclasses, this case simply cannot proceed. Thank you.
Thank you. You have about 1 minute and 28 seconds left on your rebuttal.
Thank you, Your Honor. Appealing to emotion and taking unnecessary shots does not fix the flaws that Williams 1 found with Judge Brogan's 56-page opinion and the same flaws that now appear in the 6-page opinion. Mr. Patakos made a point to say Judge Brogan's 56-page first opinion in Williams 1 did all the analysis. Well, it wasn't good enough for this court the first time because they sent it back and told him to do the analysis, the rigorous analysis he failed to do in the first instance. That's the language. And if it didn't get done in the 56, it certainly didn't get done in the 6 when you read it, because again, all he did was add subclasses. And we can play word games, subclasses, subgroups. That was his remedy, without doing the rigorous analysis that was necessary. Now I'll end. Mr. Patakos brought up named plaintiffs who aren't anymore because they did receive a reduction, Thera Reed and Richard Harbor, again to tug on emotion, to say what was done to these people was awful. Well, look at their testimony. Both of them said the trigger point injections helped them. They went back multiple times, that's undisputed, because they helped them. And Richard Harbor was a KNR client on 4 different cases, a Gubriel patient in 2 different cases. He's the one that had insurance and chose not to use it because he wanted the tortfeasor to pay his bills. So when you look at everything in total, look at the actual facts and take out the hyperbole and the unnecessary shot taking, the fact remains Judge Brogan failed to meet the mandates of this court and Rule 23, and Class A cannot be certified, must be decertified.
I'm going to need for you to wrap up.
I'm wrapped up, thank you.
All right, thank you very much. Thank you all for your presentations. The court will take the issue under advisement, issue a decision in due course. The clerk of courts will mail a copy of it to you on the day that it